Welcome to today's meeting of the Wingecarribee Local Planning Panel. My name is Michael Manty. I'm the chairperson of today's meeting. Can I start by acknowledging the Gundungurra and Tharawal people as the traditional custodians of this land we now call the Wingecarribee Shire. I pay my respects to elders both past, present and emerging. I would also like to extend that respect to all Aboriginal and Torres Strait Islanders present here today. The other members of today's panel are Linda Kelly, Scott Barwick and Robert Stas. Before I call the first item on the agenda, I'd like to briefly explain the role of the panel and the meeting procedures. The Wingecarribee Local Planning Panel is constituted under Part 2 of the Environmental Planning Assessment Act and is authorised to exercise functions of Wingecarribee Shire Council in respect of development applications under Part 4 of that Act. The panel is not subject to the direction or control of Wingecarribee Shire Council except in relation to any matter relating to the procedure of the panel. As I said, the role of the panel is to determine the development applications on today's agenda. We will determine those applications by either, in respect to the first item, either endorsing the panel's original decision or approving the application, and in respect of the second application by either approving or refusing the application. In exceptional circumstances, the panel may defer its decision on the applications before the panel today. For the record, each of the panel members has familiarised themselves with the sites of each of the applications. We've also been provided with the plans, reports and other documents submitted with the application and copies of written objections. The panel cannot receive any additional information from an applicant that amends an application. If an applicant wishes to amend an application from the floor of the panel meeting, then the matter will need to be deferred and the additional information will need to be submitted to council officers for assessment in the usual manner. In terms of meeting procedures, I will call your name. If you're listed to speak, I'll call your name when it's your turn to speak. We'll hear from the objectors on each application first and then the applicant's representatives second. I ask if you can please keep yourself on mute until you are invited to speak. If you're experiencing technical difficulties or if you cannot hear me or the speaker, please use the chat function on your Zoom console. Presentations to the panel should be limited to 3 minutes each. The panel chair has the discretion to extend the period if required. I ask that only one person speak at a time. After you've spoken, the panel members may ask questions. At the conclusion of the presentations, and if there is no further questions from the panel members, the panel the public part of this meeting will be closed and the panel will convene in private to agree on its findings and prepare the panel minutes. The meeting will then be reopened to the public once the panel has determined each application, and the panel's decision will be delivered in public. The panel's minutes will be published on the council's website within 48 hours of today's meeting. Can I reiterate that this meeting is being recorded and webcast via council's website, and a person's image and or voice may be publicly broadcast. There are 2 items on today's agenda. Before I call the first item, can I ask panel members to declare any conflicts of interest?
Mr. Chair, it's Scott Barwick. I've declared a non-significant, non-pecuniary interest in both items. I've in the past worked professionally with Mr. Lee, who is making presentations, but I don't believe that will hinder my judgment and deliberation on the matters. Thank you.
I have nothing to declare.
I have nothing to declare also.
it is. You're back, Michael. Audio still not working just yet, Mike.
You're on mute. It's telling us it's connecting you, so you should be back in a minute.
I beg your pardon, everybody. Can everyone hear me now? I'm sorry.
Yeah.
I'm sorry about that. I was up to the conflicts of interest. Can anyone, if anyone has any conflicts of interest to declare, please declare them now.
I'll do it again, Michael. Yeah, I've completed the form. I do have declared a non-pecuniary, non-significant interest in both items. Mr. Lee, the planning consultant for the applicant of both applications we're considering today, I've worked professionally with in the past, but I don't believe that is a conflict that would exclude me from deliberating today.
Okay. Any other conflicts? No?
No, I have no conflicts.
Okay. Thank you. And I do not have any conflicts of interest either. The first item on today's agenda is an application to review a previous decision of the panel to refuse a development application for subdivision, two-lot subdivision of land described as Lot 313 DP 1245164, being 27 Kimberley Drive, Bowral. The previous panel decision was to refuse the application. The application before the panel today is to review that determination, and the council officer's recommendation is to approve the application subject to conditions of consent recommended by the council officers. I have on my list a speaker against the proposal, Mr. Peter Rowe. Mr. Rowe, are you online, and would you like to tell the panel what your concerns are? Have we got Mr. Rowe?
Yes.
Yes, Mr. Rowe?
Yes, Peter.
Yes, yep. Peter. Can you please tell the panel what your concerns are about the application before the panel at today's meeting?
Okay, thank you. I've missed all the introductions, so I'm not sure what's happened. My name's Peter Rowe, and I live in Village 20 at Milton Park. I'm speaking on behalf of the objectors today. Firstly, we did not receive notice of this matter coming before you today, and we only heard of it by chance on a Monday evening. This is the second time we've not been given proper notice by council in relation to this matter. We have, in the time available, provided you with a further objection in response to council's report. We have done this with the assistance of a planning expert. A letter of objection gives 5 grounds why the application should be refused and gives reasons in support of those grounds. Those grounds are that the application is not in the public interest and has a detrimental impact on services. The report has not adequately addressed the issues raised in the previous objections and the assessment of the WLEP and Rural Lands DCP and applicable controls on subdivision of land and services. 3, the additional information submitted by the applicant for the review has not adequately addressed the planning panel's reasons for refusal. 4, the decision to refuse the original application by the planning panel for the various reasons outlined in its decision continued to exist. Excuse me. The applicant has incorrectly relied on clause 4.2D as a means for seeking approval for a lot that is less than the minimum lot size. Inaccuracies in the report are mentioned in our letter. There are other inaccuracies, including restating the applicant's statement, which I will quote. The approved strata titles Arts and Crafts Centre comprises the hayloft, the carriage house, 2 adjacent managers' cottages, and the AI Centre, all of which are original historical elements of the Milton Park estate, and all of which are being used in accordance with the original consent. Council has repeated that statement and relies upon it in its report, despite being advised that 1, there is no approved strata titling. 2, the Arts and Crafts Centre's original approval was for the hayloft building only. 3, the hayloft and the carriage house are now being used for tourist accommodation, which was not part of their original approval. 2, the 2 managers' cottages are being used for residential accommodation, and 4, I should say, and 5, the AI Centre is used for other purposes. It's just an example of the problems with the report. The report fails to properly address objections. An important one that is not covered in our letter. Sorry, I've had to limit this in the time available to me to prepare this. Importantly, we have pointed out that the approval for the demonstration house on Lot 1 requires it to be part of a registered strata scheme. That was one of its original conditions of approval. The applicant sought that it be part of, or sought to satisfy that by having it that recognised in its 2011 application LUA 110869. The response does not address how this strata titling can be achieved if the house is part of Lot 1 and which is not part of a strata scheme, and there is no intent to have it as part of such a scheme. The response in the report to a registered strata scheme for Village 2 is irrelevant because it's on a separate lot. It doesn't explain. It just says there's going to be a strata scheme for Lot 2, which is for what will be contained within Lot 2. This other Lot 1, where this house sits on, is to be sold. Even a friend of mine looked at it for sale last year. Further, the applicant has acknowledged this difficulty as it is now seeking a separate variation application to have the previous strata approval for this house revoked, after acknowledging that the demonstration house's approval required it to be strated. There are no reasons given for this request in the relevant application. This has been drawn to Council's attention but ignored in its report. It hasn't even been touched upon. So in the time available, I've just highlighted some of the information, the deficiencies. Those are more particularly described in the letter of objection that we sent to you yesterday, which was very limited. Personally, I've been in board meetings for most of the last 3 days, and I was writing this thing at 5 o'clock this morning. And fortunately, I'm able to speak because one of my boards finished early today. In conclusion, the review does not meet. Finally, I seek the panel to carefully consider what is said in our letter to you and what I have said today. The review does not meet the statutory or discretionary requirements for the panel's original decisions to be reversed and should be rejected. Thank you.
Okay, thank you, Peter. Is there questions from the panel members? Anyone, any questions? Yep.
Sorry,
Scott Barwood.
Just if Mr. Rowe could just clarify for me where the demonstration house is on the site, just so I clearly understand where he's talking about.
Yep. If you look at Lot 1,
yes,
And I'm just speaking from memory, if you look at lot 1 and you look at Kimberley Drive,
Yes.
identify that and you'll see there's a roadway coming up from that and that there is a house quite close to that.
Okay, so
in the bottom, sorry, what I call
it
is
the top.
West corner of the top. Now that's about a kilometre away from Village 2.
Okay, thank you. Nothing further from me, Mr. Menti.
Any other panel members, Robert or Linda? Questions for Mr. Rowe?
Nope, I have no questions.
No, I don't have any questions.
Okay. Can I just clarify also in relation to the demonstration house? Is it correct that you said that that there's a condition on the original consent is it 11/0689? Yep.
Interrupt. The applicant made. It's all a bit. It's a bit complicated, and I used to be a solicitor. I was in financial services. I've never practiced in property law, and I haven't not tried to get on top of all of this stuff. There was a separate consent granted to the building of this property back in 2003. And I'm not going to try and describe all the conditions for the original approvals granted in 1984 and 1985, but in my view, the original approvals to allow the Village 1 and Village 2 required that the villas be strata titled. And that was necessary to get government, as part of the government approvals. And the demonstration house is one of those 44 buildings. This was acknowledged in a letter by the applicant to council, and that letter was sent in January or early 2011. And it was included in the applicant's rebuttal pack as an annexure. And it was subsequent to that the council gave or stated that the demonstration house was part of the approval for the remaining 24 villas for Village 2. That's not a precise legal explanation. It is more of a layman's explanation. The reference to the demonstration house and its size and purpose was included in the decision of His Honour Justice Campbell in a decision issued in 2005 in a case of Tugillo versus Watts, which was in relation to our recreational easements.
Okay.
He specifically mentioned that train that I was just referring to, but there's no reference to it in that decision, and that has been pointed out in our submissions to council on this matter.
Okay. So what in your view would be unsatisfactory about the demonstration house not being included as part of a strata plan? What would be unsatisfactory about that?
Well, if lot 1 is a separate lot to lot 2. Lot 2 is to be part of a strata plan. Yep. So why I said in what I was saying, the application has not mentioned how lot 1 can be included in that strata plan, or that house can be included in that strata plan. What it has mentioned is that they're two separate.
Yeah, we understand that.
And so I can't see how you can have. I'm not saying that you can't have lot 1 as part of that strata plan, but it hasn't been mentioned in the application. And as part of the application, you're supposed to be considering all aspects of these matters. And all I was trying to do was demonstrate how the council's report is deficient when looking at the objections. There is possible means of getting around it. I haven't turned my mind to it, but you could imagine that Lot 1 could be part of the same subdivision as Lot 2. Then why have this subdivision that we're dealing with today?
Well, the application before the panel, as I understand it, is to create 2 Torrens title lots. Lot 1, Lot 2, and that with the intention that Lot 2 will contain Village 2, which will be the subject of a further strata plan. And I'm just trying to understand your objection is that you're saying Lot 1 should also be part of that strata plan.
I'm just saying that how can it satisfy how can the house, the demonstration house, satisfy its condition of approval to be part of a strata plan when it is not part of any strata?
Well, things move on. Things move on. Assuming that the panel has the power to approve an application that is contrary to that original approval, what is unsatisfactory about Lot 1 not being in a strata plan?
Well, I'm not saying that. I'm just pointing out, as I said before, the deficiencies in the report.
Yeah. Okay. If it is a deficiency, I want to understand what the consequences of that deficiency are.
No, I'm not a property lawyer, but I've just pointed it out to council, and council hasn't demonstrated a response to that. And that's the issue, because it just shows a lack of proper consideration of the objections.
Okay. Any other questions from the panel members arising out of what was just said then? No? Okay. Okay then, Mr. Rowe. Well, thank you very much for addressing the panel.
Thank you.
I'll ask you now to put yourself on mute. Just for your benefit, you said you didn't hear the introduction statement that I made. What will happen procedurally is that there's 2 items on the agenda. After we finish with the second item, the panel will adjourn in private and discuss our findings. Once we have agreed on a decision on both applications, the meeting will then be reopened online in public, and the decisions read out online. The written minutes will be available on the council's website within 48 hours.
Okay, thank you.
Okay, thank you, Mr. Rowe. Now, I have 2 people listed to speak on behalf of the applicant, Mr. Dobler and Mr. Lee. Are you, both of you, online? And who would like to speak first?
Mr. Chair, thank you. Scott Lee speaking. I think it's working. You can hear and see me, perhaps. That's good.
Yes.
Thank you.
Yep.
Yes, I'm speaking on behalf of the applicant for Dobler Properties, and Mark Dobler is with me if required to help answer any questions you may have. Put simply, we believe we have an application before the panel that is an appropriate use of the planning provisions that apply, namely Clause 4.2D of the LEP. Council's original assessment report reached the same conclusion and recommended approval of the development application. Subsequently, we lodged a review application, provided additional information, which the panel obviously has now, and Council had an independent assessment report done, and that has also reached the same conclusion, that it is worthy of support. We're very pleased to stand by that assessment report. I'm happy to answer any questions. I don't wish to make too many comments in relation to the previous speaker, other to say that none of the points raised are any different to those that have already been expressed previously and assessed by both assessment reports that have been prepared on behalf of the council and in submissions that we made, particularly in our 8.2 review. So those questions have been answered. Fundamentally, what we are seeking to achieve is a subdivision to create 2 lots, one of which will be a 40-hectare compliant lot that has a dwelling house upon it. That dwelling house was approved some time ago, almost 20 years ago. There is no condition of development consent that requires it to be part of a strata plan. it will sit on a 40 hectare compliant allotment within the E3 zone. And as you've just been advised, it's approximately 1 kilometre away from the development site of Village 2. The second lot in our subdivision is less than 40 hectares, but as expressed in all of the applications, or both the applications we've put forward and both assessment reports, Clause 4.2 is an appropriate mechanism to deal with a lot that is less than 40. The history of the site has been well expressed in all of those assessment reports, and quite bluntly, 40 hectare minimum requirement in this case is simply not relevant. The purpose of the application of the subdivision is very clear. It's to facilitate the approval that was granted some 35 years ago, Village 2. Subsequent to the creation of the Village 2, it also will be strata title subdivided in exactly the same manner as Village 1 that was already upon the site. So there's nothing unusual or different about the proposition. It's a continuation of an approval that was granted some time ago and gives effect to that approval. That is a legitimate and very appropriate use of the provisions of the LEP as they exist today. There is no environmental impact arising from the development application because that's all been dealt with under other approvals. There's a relevant approval for Village 2, in fact, a construction certificate, and in fact, it's under construction. So the subdivision in this case is very much a management exercise to give effect to the original approval of having a number of strata-titled villas in 2 distinct villages. And that's the intent, and that will be the outcome. I'm not sure I need to say anything else. I mean, like I said, the panel now has the benefit of 2 assessment reports from the council, one from its own officers for the original application and one from an independent planner on the review, and both have reached the conclusion that it is worthy of support. We've provided everything that the council has requested of us in terms of information to assist in the assessment. And the only thing remaining now is if you have any questions, myself and Mark will do our best to answer those for you.
Okay, thanks, Scott. Scott Barwick has got a question.
Just to confirm, just to make sure we're talking apples and apples. So, Mr. Lee, the dwelling that would stand on lot 1, that's the dwelling that Mr. Rowe described as the demonstration house. Is that correct?
Yeah, that's correct. That comes off Kimberley Drive and it's in that northwestern corner of the site.
Yep. Just wanted to make sure.
That's the one.
It's the same one.
Yeah.
Thank you. Nothing further from me, Mr. Chair.
Any other panel members got a question for either Scott or Mark?
Nope, I have no questions.
No question.
Robert Stas?
No, I have
a question. Scott, just you said that there is no condition of the approval for the demonstration house that it be part of a strata scheme. Is that right?
That's correct. That house was approved, I believe, in about 2002, 2003. Not sure if the report references that particular DA number. I think perhaps there was some discussion in the assessment process for the 2011 application where it was considered at one time that perhaps that house would be part of the 24 villas. There was the original approval original development gave approval for 44 strata title villas. 20 of those were constructed in Village 1. There was 24 remaining. And that the 2011 consent at one stage contemplated one of those remaining 24 to be that house. But that was never a condition of consent on that dwelling that it be part of a strata scheme. That idea of making it one of the 44 is no longer part of the proposition. It's its own house on its own, or will be, if this is approved, it'll be a standalone house as it is now on its own 40 hectare compliant allotment, which it's not one of the 44 strata titled villas from the original approval. That's a confusion, I suppose, from Mr. Rowe's point of view.
Okay, thank you. And in terms of clause 4.2D,
Yes.
of the LEP, the necessity test. Can you just explain what the planning purpose of the two-lot subdivision is? And in your answer, can you also explain what the alternative would be if this subdivision wasn't approved? So, in other words, why is it necessary for this subdivision to be approved in order for the villa development to be completed?
Well, we're trying to give effect to the original development approval, which was for strata title villas. That was a major component of the overall development. And to do so, we believe it's necessary to create that, I suppose, the platform for that, which is the area that is occupied by Village 2, in exactly the same manner as was done for Village 1. Village 1 was created not long after the original approval, and a lot was created for that purpose, and those villas were strata titled. It allows the management, the proper long-term management of those villas, the owners of those villas, to operate in an effective manner. So in that sense, what I've said before is that the subdivision is a management exercise as distinct from trying to facilitate a different development outcome. We have the development outcome. We need to create the building blocks to enable that to be managed effectively. So the best way to do that, in our mind, the most effective way, is to create this lot, which describes the development parcel for Village 2, and that allows then the subsequent strata subdivision to be linked to a parcel of land. It's purely and simply the best, most effective way to manage the development as it is already approved. That's, unless Mark has other comments, that's the reason why it's necessary.
Okay.
That's the conclusion reached in the assessment report as well.
Yes. Yeah.
Mr. Lee, would the other half of that be then also that you then have what was described as the demonstration house is on one large compliant E3 40 hectares lot as well?
Well, that's right. I mean, it's its own entity, if you like. It's the access for it. Like I said, it's about 1 kilometre away from the area of the site that comprises Village 2, and it has a different access or address, Kimberley Drive. It was approved, never approved. It was approved as its own separate dwelling house back in 2003. So there is, it doesn't have the same connection, if you like, to the Milton Park Group as these villas do. So it's, as a compliant 40 hectare lot, it can be managed in that way. As a rural lot, it's completely within the E3 zone. And it makes, I suppose, it's a logical parcel of land with one dwelling house already on it, whereas the other second lot is also a logical parcel of land to accommodate the villa and arts and crafts centre component of the original development. So this, quite often, subdivision becomes before the development, okay, and then it goes from there. In this case, it's the reverse. The development is there. It's been approved. We know all about that, what happened there. And the subdivision is simply to allow that to be managed in an effective way. So nothing changes from the original development other than the ability to manage it properly into the future with this new village. Seems to us to be a very effective use of that clause.
Okay, thank you.
Is there a reason why the effluent disposal system was never located within either of the lots comprising Village 1 or future Village 2?
Well, I think that facility's been located where it best functions. Okay, it's practical location for it within the broader area. It was probably the original approval identified the general location for Village 1 and Village 2. It was always the necessity to have an on-site system like that, and that's been in place ever since the approval was put in place. it was never functional or reasonable to have that facility amongst the residential or the village development. So it's always been in that location, and it has the appropriate, easements and rights and benefits to service the development. It's always been a functioning part of the site, and there's never been a problem with that. And this subdivision will allow it to be managed in the appropriate manner. It's in the most appropriate location.
Okay, thank you. Well, I think that might be the end of the questions. It is from me, at least, anyway. There's no one else puts their hand up in the next 2 seconds.
Can I ask, Scott?
Yes, Robert.
If the subdivision didn't take place, would the strata group in Village 2 be responsible for the maintenance of the whole of the 40 hectares as part of their responsibility?
Yes, it would. I mean, there would have to be...
They'd be responsible for the whole of the rural landscape.
That's right, which doesn't seem to us to be the most effective ongoing arrangement for anybody. Right. Whereas the lot 2 is more is better defined and more particular to the interests of the people that will be living within that village.
And I assume that Village 1 has no responsibility for any of the other land, and that it's
that's correct. Yes, Village 1 is similar to what we would like to do here. Village 2 is a discrete parcel for the village, not including any of the surrounding rural land. So we're not doing anything that's different to what Village 1 already is.
Thank you.
Okay then. Well, I might thank you, Scott and Mark, for assisting the panel, and I'll now close that item. Is there something you want to say?
Thank you, Chair. Just in relation to the second item, would you like me to stay because I'm involved in that?
Yes, please.
Okay.
Yes, if you can stay on.
Okay, thank you.
Right, so I'll move on to item number 2 now. And item number 2 is, pardon me for a minute. Item number 2 on the agenda, which is called item 5.2, is a development application for subdivision / boundary adjustment between 2 lots described as lot 4 DP 339390 and lot 6 12732 at number 36 Kangaloo Road, Barrel. The council officer's recommendation is for approval subject to conditions. We have no people registered to speak against the recommendation, but Mr. Lee, you're here as the representative of the applicant. Are there any questions? Oh, well, firstly, do you want to say anything to the panel?
Thank you, Chair. We obviously support the recommendation for approval. Just by way of explanation, that there are 2 lots existing. Technically, it would have been possible to have used the provisions in the Exempt and Complying Code to do a boundary adjustment without a delay. However, my concern was that in registering those 2 new lots, it may have had implications on the provision clause 7.1 in the LEP that deals with development on existing allotments that are undersized, and I didn't want that to happen. So we lodged a development application. So even though these lots, one in particular, would be undersized, they would come about through a development approval issued by council, and therefore there'd be no question about their dwelling entitlement into the future. That was particularly relevant for one of the lots, the smaller of the lots, because it's currently vacant. And I didn't want a situation where we registered a lot without council approval and the council saying, well, there's nothing we can do because it's too small. The purpose of the subdivision originally was to deal with a small encroachment of the dwelling onto the access handle of the second lot. So there was a practical purpose, and then there was a planning purpose why there was a DA lodged. Very happy with the recommendation of the council officers.
Okay, any questions of Mr. Lee on that item?
Okay.
I have one question. It seems like a major element of the justification to vary the development standard is that there is an existing dwelling entitlement for the vacant lot under clause 7.1 of the LEP, and that clause says, well, basically, if you had an entitlement under the previous plan, then you've got an entitlement under this plan. Have you investigated? You have investigated whether there was a previous entitlement under the previous plan. Can you just enlighten us on that?
Yeah. Previous to the LEP 2010, the 1989 LEP, I don't have the report in front of me, sorry, but was similarly residentially zoned, and dwelling houses were permissible in this area. The lots themselves were created even prior to the 1989 plan, and the house exists on the street frontage lot. So as far as I could ascertain, and what I put forward in the statement of environmental effects, was that both lots were created for the purposes of residential development. One of them was developed in that manner. The rear lot always just remained as a vacant lot. The 1989 plan came and went, and the provisions as they apply today, in my opinion, would have allowed council to consider a dwelling on this lot, notwithstanding it's less than the minimum lot size. The minimum lot size doesn't prohibit housing. It's for the creation of new lots. When you've got a lot that's smaller than the normal, you just need to satisfy some criteria. The purpose for the DA was to make sure that we didn't trip ourselves up by suddenly having a lot that was not created prior to the 2010 LEP coming into force, and somehow losing our rights under clause 7.1. Because council questioned me on that. Why have we got the DA? Why can't you just do this as an exempt development? And that was the response. And I think I'm correct in being cautious about that. And so therefore we lodged the DA. The justification for the variation is strongly on the basis that circumstances aren't being changed, but it's also some site-specific circumstances there where the land parcel, although it's not the 2,000 square metres, is quite easily, it has a nice level building platform that would sit nicely in its context with neighbours. There's a lot of medium density development established along Kangaloon Road, so the density of development that results from this is not actually very much different to the prevailing density through there when you take into account all the medium density that's already existing. So we think it's just on all perspectives, it's just a good fit and the right thing to be doing.
Okay. Thank you. That answers the question. Any questions from panel members?
Nothing from me.
No?
No.
Nothing from Linda? Robert? Okay.
No.
Right. Okay, Scott. Well, thanks
Thank you
for your assistance.
Thank you.
As I said, we will now adjourn in private to discuss our findings and agree on our minutes, and we'll then reopen the meeting at some time in the next 2 hours. Yep. Thanks, Scott. Okay, well, I'll now formally close the public part of this meeting for the time being. The panel will now adjourn in private, and the meeting will be reopened to the public sometime in the next 2 hours after the panel has agreed on its findings for the purpose of reading onto the record the panel's decision.